Any mention? Any mention?
Please for the EC.
May I be pleased, Your Lordship?
Yes.
Lordship, I would like to mention item number 21 to 104. 21 to 104.
21?
To 104.
21?
Yes.
For 21 to?
104, Your Lordship.
Why?
Senior counsel is not well here.
Who's senior counsel?
Dr. Frank.
She's not senior counsel, she's your senior colleague maybe. Yes, where's the other side? You inform them?
Yes. Lordship, I have.
Where's Mr. Deb or Mr. D or Mr. Just wanted to finish his matters today. We have it when on Friday?
Okay,
Next week, after 1 week, as the arguing counsel stated to be, arguing for the respondent stated to be unwell. Yes, 21 to 110.
110.
104.
104, Your Honor. 104.
Yes. Yes.
And you've lodged.
You appear on whose behalf?
On behalf of the petitioner.
Okay. You should say that just now when it's asking where's Mr. D. You should say that I am here on behalf of the petitioner. Correct? Okay, yes. Yes.
Lordship, I'm back to mention item number 18 of the hearing list. Lordship.
17 you do today?
Lordship, 17 I have no instructions regarding 17. Lordship,
No adjournment, 17. 18 for what?
18, Lordship, senior counsel is not here, Lordship. Okay. Senior counsel has some difficulty, Lordship. Has some difficulty, Lordship.
He's not, he's in station.
Lordship, he is in station.
Okay, 2 weeks is.
Lordship, similar prayer for item number 19.
Okay.
Lordship, item number 17 as well, Lordship.
Mr. Das has objection.
Lordship, last days it is an objection in this, and for the last 12 times they have taken an adjournment.
We are not adjourning
So
this matter. You are here? You could.
I'll take instruction, Lordship.
No, not instruction because he's objecting. Yes, follow the list.
Obligation.
Supplementary list item number 1.
May it please your Lordship.
Yes.
Lordship, this petition is with regard to the issuance of the duplicate scheduled tribe certificate. Lordship, here in this case what happened is the petitioner herein is working in the Atomic Energy Regional Center for Exploration and Research, which is shortly as AMD, Lordship. And in the year 2018, he had applied for the issuance of a duplicate scheduled caste certificate, Lordship. And
why is duplicate lost the original?
Lordship, because he had lost his original, and this was reported also, a police report in that regard also was there, Lordship. But since 2018, Lordship, after the application on online and after being verified, being called to appear before the concerned authority, Lordship, that is the respondent number 3, and that also along with his aged mother, who is aged about 82 years, she had to come along with him for the verification of the papers, Lordship. But till date, Lordship, nothing has been issued to him, and he is about to superannuate on this last day, Lordship, that is on the end of this August 31st August, Lordship, and he is yet to receive the
what is the problem?
We'll have to take instructions, Your Lordship.
Yes, by tomorrow, Tuesday, Thursday. Right, MS room, we have the petitioner issue notice. MS the renowned country is present behalf of
1, 2, and 3, Your Lordship.
1, 2, and 3. Yes, as from how wise only for present behalf 4, 5, and 6. No further notice called for. Stop the grievance with petitioners that in spite of making application for issuance of duplicate scheduled tribe certificate since 2018.
Yes, Lordship.
The same is yet to be processed or the duplicate issued to the petitioner. Stop. it is further submitted that the matter is of extreme urgency, inasmuch as the writ petition due to superannuate in the end of the month. For
Yes,
which
Lordship, that is only
submission of
31st
the welfare
April.
certificates necessary for the settlement of his necessary for submission for his terminal benefits, pension, etc. In that view of the matter, as paragraph learned government advocate to obtain instructions immediately within 2 days, list the matter on
Friday, Your Lordship.
Friday.
The copy of that ST is there, Lordship. It's an annexure.
Copy of the order be
30.
given to the net GA for communication to the concerned respondent.
Obliged, Your Lordship.
Highly obliged, Lordship.
Item number 2.
Please, Lordship. Lordship, this here the petitioner he was working as a master role since for past 10 years. Lordship, he has appeared as a master role on first 10th October 2013, and he has been continuing as in a master role. Now immediately after working as on the seniority base, he is also one of the seniority in the master role, and then on the basis of his seniority, the executive engineer PSC division. Rishubel Para. He has made an arrangement for 89 days. He has made an appointment on 2nd June 2023 with effect from 1st June 2023. And that immediately the petitioner have written joining application on that same day, and then he has joined. But interestingly, sub-divisional officer PSC Bajingtoba, he refused to entertain and is not allowing the petitioner to join in service.
Why this Lecture 6? This is 11 July. Investigate into the matter. What investigation?
Because this is the some master road association. They have filed a complaint saying that the petitioner should be.
Why you have gone to Master Road Association?
They said that they said that they have no any
You're
objection.
the leader of the union.
They are in the union.
You are the leader of the union.
I'm also one of the union.
Leader or just a
No,
member? of the
no,
union?
no, just an association. I mean, they are a member of the association. So the member of the association, they have taken up the matter, and they say that there is that they don't have any objection with regards to the arrangement of 89 days for the petitioner, and they approached then this. Additional chief engineer directed the superintendent engineer to investigate into matter. But however, that till now there is no inquiry that is still.
What's
still
your
pending.
name?
Lordship.
Name is?
My name is Kibito, Lordship. In the in the master road, I'm 100 serial number 105. 105 Kibito. He was appointed on 1st 10/2023, and my appointment by the executive engineer executive engineer is the annexure 2, my lord. That is at page 20.
So your union has asked for transfer of the officer also who
Actually,
allowed to join.
it is the.
You see, the demand even transfer from Garo Hills to Khasi Hills and not posting in Garo Hills region for a misbehavior, misconduct of the master role of Garo Hills and action sitting against her. Therefore, we serve ultimatum 15 days after his letter. So you give ultimatum to the officer also.
Actually, it's not a petitioner.
You feel to respond demands start additional program at PH subdivision office Bajang Doba in a democratic way to show dissatisfaction to the department. So you're working as master role in the department. Now you're a member of this all Meghalaya master role progressive workers union.
Actually,
Oh yes, you have a nice leader. Offices. So you make the demands that
it is the master
you
or
want
association.
SEO
They take an
SEO
initiative.
to be removed from there also.
Actually, they're supporting. They're saying that the complaint, the petitioner have no any other there is no
But
any.
all working as master role in PHE, is this the way to demand?
Of course, actually, it is not the petitioner who take the initiative, but it is on behalf of the petitioner. This association have stand on his behalf. Actually, the petitioner have nothing. He has not said anything, but they have taken their own. But I just bring to this.
Given certificate also to the external exhibition that the petitioner is hardworking, very sincere, and we strongly recommend the case. Yes.
Otherwise, this is a stopgap arrangement. Actually, there is no bar, and the government from the government also. Actually, he's a sub-divisional officer. He should comply
Okay,
the order.
Mr. P.T. Sama, you take instructions. issue notice. Mr. S.E. Sheikh, then the GA is present and accepts on behalf of all of respondents. No further notice called for. This is a matter after 3 weeks for instructions or affidavit.
Lordship. Lordship.
Main list item number 1.
Your Honor, these appeals are already listed, admitted. No, these are ready for hearing. He was to file the amended petition.
They all been admitted.
All appeals are admitted.
Is that correct?
Lordship, in item number 6, Lordship will recall we had to file a recast petition after the amendment, which we've already filed. So matters are ripe for hearing, Lord.
Matters are ripe for hearing.
Parties submit that the petition that the appeals had been admitted on an earlier occasion, and what was remaining was only for filing of amended
appeal,
apparent memo of appeal.
That is in item number 6. In FA 1 of 22.
In FA 1 of 22. Which are submitted by Mr. S.N., then a senior government advocate, has since been complied with. Accordingly, yes, all these connected matters. When?
As my learned senior was suggesting, Lordships may require a paper book.
Yes, of course.
So I'll have to prepare a paper book.
Yes.
So let it be after 4 weeks.
But then it will be separate paper books. There will be a lot of. But then will the evidence be? No, but will the evidence
no, there are only evidence and the exhibits.
Will evidence be common?
No, for petitioner separate, but there are certain common evidence of 5-6 witnesses.
We don't want that to be mixed up.
No, we can only make the paper book consisting of evidence, because pleadings, so they haven't filed any written statement before the.
As far as we are concerned in item number 6, we'll see whatever is relevant. We'll introduce all of that in the paper book. Memo of appeal is not required, but whatever pleadings were before the court, we'll bring that on record and the evidence.
The pleadings have been included. Okay. Yeah, those appeals have since been admitted. On an earlier occasion, not other occasion. Amended memo of appeal. It is submitted, submitted by Mr. S.N. that the same has been complied with. And that amended memo appeal has been complied with. Stop. Next, interview the matter. A paper book. School prepare a paper books.
In 6, I'll prepare the paper book.
So that will be common for all.
No, it won't be common for all.
For item number 6, if he prepares, then for others I will prepare.
Yes. Complied with. Stop. Accordingly, paper book for this is
consisting of evidence
of 2022, consisting of the evidence or deposition
and exhibits
to be prepared by the appellant. Stop. With regard to the other connected appeals, stop. Mr. V.K. Jindal, Fiancé Counsel, submits that the same will be prepared by his office. This is matter for hearing after 6 weeks.
I just have one request. In item number 6, Malaj have indicated the pleadings and the evidence. Lords will recall there is an issue of maintainability which has been raised because we filed a composite appeal. Now, I would also like to bring on record the reference order and the original reference which was placed, that will have some bearing, my lords.
You can place whatever.
Lordship.
If the paper book number 6 and whatever materials are necessary. Yes, and in the other ones, you prepare a paper books. 6 weeks.
But your lordship, there are 6 appeals which I have filed, but he has to give me extra copy of the.
I'll supply that. I'll supply that. I'll supply that.
Yes.
It's very difficult for me to prepare.
Yes. List after 6 weeks.
I'll oblige.
Item number 5.
May I please?
May it please your lordship, I'm praying if this matter may be passed over for the time being and be taken up after some
Nothing in
time.
the matter.
No, my lord. My lord, there are 2 things, my lord. One, the election can be declared illegal or no, my lord.
I mean,
My lord, there is a
this
difference.
is
My lord.
futile.
No, my lord, there is a difference. I'll satisfy lordship, my lord.
I thought I'll write the judgment.
My lord will see my prayer. My prayer is only.
We'll see, but then I don't understand on what basis this petition been filed.
No, my lord. I am
Court
just.
doesn't understand. Not I. Yes. Okay. Yes, Mr.
Obliged.
Item number 9.
Lord, the counter affidavit is yet to be filed, my lord. My lord, this may be the last chance, my lord. It should be given to them.
Where's 234 GCDC? Is it Rimbai? You already filed?
Not yet, Lord.
Then how long are you going to take? Where's Dr. Mosika? Of course you have to pay some time, not file your affidavit.
My lord, this may be the last chance, my lord. Many times.
Last chance has no meaning. It makes a mockery of the court and the system. Further 2 weeks' time, as praise granted, response to file affidavits. We expected the next day the affidavit should be on board. Just on so and so.
Obliged.
10.
Lord, I have just received the otherwise comments, my lord. I will be filing my prayer.
Very good. Ms. S.A. Sheikh has entered appearance today. We are responding before. So such the service is complete in all the respondents. Mr. N. Sinkon, please be allowed. How much further?
3 weeks' time, my lord.
You can file affidavit.
Your Lordship, in this case, this pending of the writ petition, there shouldn't be any bar to release my current salary.
Order is already there, my lord, to that effect. Order is already there to that effect, I think, if I am not wrong.
It's not yet given, so that's why, Your Lordship.
Not given what?
My current salary, Your Lordship. And to make payment in my account, not by cash.
The matter is still pending.
It's already given order 15.6. So you agitate nothing to stop this for 3 weeks.
Obliged.
11.
Is ready?
Yes, Lordship. So I just pray for
Very good.
3 days time, but I got the series now. The only time need to annex some annexures and file it, Lordship. Even 2 days also not.
It can be filed today, sir. Since it is ready.
You didn't bother to appear last time, Mr. Anar.
My lord, I was not. I missed the cause. In fact,
Mr. Lordship, I am on behalf of the petitioner's wife, Lordship. I have not inducted his party in the petition, Your Lordship. Because petitioner wife is the main objector.
You filed for impleadment then?
there is
Objector to whom?
My lord, the case is like this. My pension has been stopped on an application filed by the wife.
Which wife?
My wife.
By filed by him?
Yes.
Then why you didn't array them as party?
No, my lord, here my pension was stopped on that basis, my lord.
Exactly. Then if they have an objection, then put them as party.
Now they have come for objection.
No, what does it mean they have come? You should have put me a party.
You
thought that.
Let's
see your impute order. Wait. You're not even a party yet. You're not allowed to speak. In fact, where's the stoppage of pension?
It's page 19, my lord.
No, 19 is your representation. It's the letter by your Sankari Burman.
Yes, my lord.
Where's the letter stopping the pension?
Here's the letter with me here, my lord.
Okay, this is page 18.
Page 18.
1st March 2023,
yes,
my lord.
You file action for impleadment. File application for impleading yourself in the writ petition. Your name?
B.R. Bhomik, my lord. B.R. Bhomik.
B.R. Bhomik. Mr. S.A. Sheikh, the GA response submits that the affidavit is ready and the same will be filed within 3 days. Stop. However, in the course of passing the order, what is
B.R. Bhomik.
B.R. Bhomik, who submits that he represents the wife of the petitioner on whose objection the pension was stopped, but he is then allowed to implead himself as necessary party, inasmuch as the petitioner has not arrayed her as necessary party, much the petitioner has not made a party in the proceedings. But he has not. You file application. File a missed case, we'll consider it, yes. Just after 2 weeks, yes. You can file them meanwhile. File.
Yes. Obliged.
Why did you make a party? You thought you'd go behind.
No. I wanted to go straight because case is pending there.
12.
Obliged.
Please, Your Lordship. Your Lordship, in this matter will bring some time since the affidavit has been sent to the department. We're still yet to receive this.
Further 2 weeks time granted to respond to file affidavit list thereafter.
13.
Lordship, I pray for 2 weeks' time. Instructions are awaited.
You're there for the petitioner?
Yes, Your Lordship.
Yes, further 2 weeks time as space granted the response for affidavit this thereafter.
Obliged, Your Lordship.
14.
Your Lordship, I pray that the matters may come up at the end of the board. Mr. Shulai is on legs and he wants to make some submissions, Your Lordship.
Because some affidavit is to be filed in this case.
Your Lordship, for instructions.
Let them come.
14 and 15, Your Lordship.
14, 15. After some time.
16.
Please, Your Lordship, this is the matter regarding that non-release of the
To
area pay and allowance.
To re-sanction that amount. It was already sanctioned once, but there was mistake, so...
Yes, what happened?
It's all right, Your Lordship. The order may be passed for
You're done.
release of the.
No, not yet done, my lord.
No, I mean, Your Lordship may kindly pass necessary orders for release of this amount, the corrected amount.
The limited prayer in the present petition is regard to the delay in releasing the arrear pay and allowance to the petitioner, in spite of the same being sanctioned as far back as on 14th March 2022. Stop. It has been submitted that
Resanction was made in September 2020.
Yes, it is submitted that due to the wrong calculation of the amounts payable to the petitioner, the district media officer is the respondent number 4 by letter dated 24/6/2022 addressed to respondent number 3 had sought a sanction for an amount of rupees
1,39,294.
1,39,294 instead of the earlier sanctioned amount of rupees 1,48,102. However, he submits, for reasons unknown, the re-sanction of the lesser amount is yet to be processed or to be made over to him. In his view of the matter, he prays that proper directions be issued that within time limit the said amount be released, sanctioned and released. Like per MSD and AAG submit instructions, the grievance of the writ petitioner is not disputed, and prays that necessary orders will be passed in this regard. So, next paragraph, considering the submissions of the accounts of the parties, it is hereby directed that the respondents grant re-sanction of an amount of rupees 1,39,294 instead of rupees 1,48,102, which is the arrears of PN allowance for extended scale. Stop this entire exercise will complete over a period of 6 weeks from today. Yes, the next paragraph, matters only stands allowed. Dispose of.
Obliged.
Hearing. So we went to this item number 3.
What do you have to say?
Please, Your Lordship, Your Lordship, I'd like to raise that the petitioner has no locus to file this writ petition, Your Lordship. Lordship, I'd like to take Your Lordship to page 13 of the writ petition.
So you are disputing that?
No, Your Lordship, page 13 of the annexure
of the
writ petition, Your Lordship.
Page 13. Yes.
Your Lordship, point number 7, Your Lordship.
Yes.
The sanad is valid only 31st December 2020, while the case has been filed on 17/10/2022.
So he is not a Sardar of who the present Sardar now?
It's the same, Your
Then the sanad, Your Lordship, for 2 years now, only this
is giving the old sanad.
This is because of COVID, no? They didn't renew sanad, I think.
20, because they filed on 17/10/22, Your Lordship.
You will record your objections, but you say 6/2/2020. Yes. Anything else?
Valid till 31st December 2020. It expires on 31st December 2020.
No, that's it. It expired on thing. Now, who's appearing for Lindo Soyong? He's still the Sardar of Lahuleng. Yes. So we'll take his submissions at the bar.
Yes.
Yes.
Your Lordship, they have also raised that the objection regarding the land record, changing of land record in this council, Your Lordship. So, Lordship, in they have raised an objection regarding that, but Your Lordship, page 14, Your Lordship, of the same sanad, Your Lordship. They have raised objection regarding the right Somaling to change to right Shnong Madan Somaling. Your Lordship, if I would like to point out regarding the boundary, Your Lordship, here they have his jurisdiction is right Khordop, but right Chnong, Badan, so Meling, non cloud aimship. So
that is not.
His jurisdiction has been set in the Senate, Lordship.
No, correct. But the
yes,
thing is that, see, if I correctly understand, yesterday when the hearing was taken up, he said that this, what is this? What is the name of the village?
Laukono area.
Laukono is uninhabited area.
No, it's uninhabited. How
uninhabited area, and it falls within Soyong, Hima Soyong, and it's not part of non-cloud aimship.
How will they
so that now that from this creation of this village, of which Lao Huliang is a parent village, has given rise to a boundary dispute between two elakas, that is Nongklau and Soyong, which is now before the tribunal. So what this court proposes to do is that, since this is a situation now and the tribunal sees the matter with regard to the other aspects, this also will be a a point of reference for a tribunal also to go into, because evidence have to be led.
Yes.
And by sitting here, we cannot decide as to where it lies or whose claims are correct. You understand?
Yes, sir.
So even the senior counsel for the Autonomous Council has also proposed that if the matters be adjudicated in a proper manner, then it will be best if the tribunal also is given charge of this dispute creation of this Laukonor village. And because the bigger dispute is between Hima Nongklau. Is represented by whom here today? No one.
Nongklau.
Oh, you're planning for Hima Nongklau and Hima Soyam.
Yes, Fajr.
So you're acceptable to that, then yes. Otherwise, you want to make other arguments, you are free to do it.
No, Joseph, the second part is regarding the appointment has been given to the acting Sardar of this.
Where appointment
of
Laukonor
has been given.
And that can be corrected, but it's by the
that point was never asserted in the affidavit position. That's why, my lord. But they have annexed the Sanat.
13 December 2020.
The said person, my lord, the said person is a resident of Madan Somleng. He's not from Laukono.
Let's see where's the affidavit. Where do you see it?
There's no statement made in the affidavit regarding that.
You are number 4.
Yes, Lordship. Paragraph number 7, Your Lordship. Page 9, Your Lordship. Second, last 5 lines. Page 7, page 9.
No, naturally will come because they'll give a point because they approved the creation of the Laukonor.
Yes, sir.
That is what they agreed with. Now your stand is that this is first he has the locus, as he is no longer the Sardar of Lahuleng, and secondly is that is the acting Sardar of Laukonor party here?
No, he wasn't.
You don't recognize him?
No, my lord. Because we are not aware of this. Because we are not aware, Your Lordship, that they have appointed acting.
But then, Mr. Kanta, will be a problem then. If disposed of, then that might, because his whole status will be
regarding
jeopardized now.
Lordship, my suggestion is very clear that the dispute is between Soyong, the Lordship, and Nokla, and a village, Soda has filed this petition. Irrespective of the fact that the ground scenario will remain as it is, status quo be maintained, and the entire issue be looked into by the present
tribunal,
matter which is before the tribunal, without touching anything, because it's concerning land. Today we pass some order. Tomorrow overnight there will be, like Nepalis in those other areas, overnight there will be swamp. We don't want that scenario to happen because it's concerning land. Let the tribunal look into this issue where the approval was given to that Lakono village.
No, it's fine. That is fine. But he has not been hurt. He has not been a party. See, he's been with civil consequences in the sense that he's been appointed as acting Sardar or whatever. But acting Sardar will have no bearing also. Only acting he can be. Anyway, okay, we'll pass orders. We'll pass it now.
Yes, so it may be subject to the outcome of this.
Of course.
Touching.
Yes. Take down the petitioner, who is stated to be the Sardar of a village known as Lao Huleng, LWHULE, Lao Huleng in Soyong, Lordship, is before this court being aggrieved with an impine order dated, being aggrieved with the order dated 10/12/2021, whereby approval has been granted for creation of a new village known as, within inverted commas, Laukanoh, LAWKANOH, within to fall within Nongklaw's aimship. So the petitioner, or not petitioner, it is submitted that though a complaint has been made to the respondents council with regard to the creation of the village, on the ground that, who is the objection? Which page?
Annexure 4, page 20. Type copy 21.
It has been submitted that though a complaint has been made to the respondents of district council with regard to the creation of village
on the ground that the same was within the boundary of La Huleng, the complaint was disregarded and approval was accorded for said creation of the village. Start. Next paragraph. It appears from the materials on record that with regard to following this dispute, then the boundary case came later on, right?
Yes, ma'am.
Following this dispute and the correction of land records, or the proposed correction of the boundaries and land records, the respondent number 4, you filed for tribunal, correct?
Yes, sir.
Respondent number 4, through its CM instituted a boundary dispute case being number 5 at 2022 against the Lingdo of against the respondent number respondent number 5 Lingdo of Soyong. Stop.
The petitioner was also arraigned as party in boundary.
Yes, that's and the petitioner in the said boundary dispute case was also arraigned as respondent number 2. Stop. The dispute as raised was that respondent number 4 number 4 was sought to assert his right over nine over certain rewrites REVS numbering 9 in number, of which rewrite Laukono is part of the same. In the boundary dispute case, it has also been categorically contended by the respondent number 4 that the claim of the respondent number 5 that the rewrite Lau Kono falls within Lau Huleng is incorrect. Stop. As reported by Mr. Vijay Kantale, Senior Counsel on behalf of the District Council respondents, the boundary dispute case number 5 is yet to be concluded. Stop. Next paragraph. Mr. R. Kharsad, on behalf of the petitioner, submits that though the objection of the writ petitioner is only based on the fact that they do not accept Lau Konor to be a separate village, the dispute that has arisen thereafter has increased in proportions, and to the extent that other areas in dispute between HEMA, between respondent number 4 and respondent number 5 have come to the fore. Stop. In this view of the matter, he submits that it would be just an expedient if the dispute regarding creation of Lau Konor village be also adjudicated by the tribunal, as the questions of disputed facts will arise as there's a question of disputed facts. Next paragraph. Mr. B. Kriam, on behalf of respondent number 4, has submitted that the writ petitioner has no locus to maintain the writ petition. The petitioner has no locus as much as his tenure as Sardar of Lau Huleng village has since expired on 31st/12/2020. he has also submitted that for Lao Konor village, an acting Sardar with the approval of the district council respondents has also been appointed by him. So in this view of the matter, he submits that the writ petition being disabled in view of the fact that the writ petition Act Locus Standi should not be given any consideration. Stop. And then Mr. Vijay Kanta, however, next paragraph, on behalf of this council respondent, has fairly submitted that the ground situation as it pertains today is that there is a dispute between two Himas, namely Nongklau and Soyong, which is seized presently by the tribunal, which is competent to decide on the matter by instituting inquiries or by taking evidence. He is also in agreement that the purpose would be well served if the dispute which is pending for this court also be taken up by the tribunal in question, the outcome out of which necessary orders will be passed thereafter. Next, Mr. C. Sangma, on behalf of respondent number 5, also does not have any objections to the suggestions as made, and has further submitted that on the question of locus, as he is the person who appointed the writ petitioner, on the question of locus, that's also doesn't have any sense made. Submitted that that the question of locus will not arise as the writ petitioner still presently holding the office of Sardar of Lao Holeng. This submission he makes is in view of the fact that he is the appointing authority of the Sardar. Stop. Paragraph, having heard and consulted with the parties and consideration of the facts and matter at hand, it is correct that it would be difficult for this court sitting jurisdiction to discern as to the competing rights of the parties, as it will involve demarcation and determination on the ground, for which evidence will have to be, for which evidence have to be led by the parties concerned. It's also noted that the larger picture is that it's also noted that a larger picture is before the tribunal, inasmuch as the dispute the boundary dispute between the Hima Nongklau and Soyong Lingdorship involves other areas as well. Stop. I find it in the fact circumstances of the case, therefore, it is directed that the present dispute, as raised by the writ petitioner, be placed before the tribunal, was permitted to file afresh. You file an additional whatever who's up to file an additional what do you call it, a petition before the tribunal, citing all the grounds for objection to the creation of Lao Konor. Stop. As this also constitute a part of the larger upon dispute, the tribunal is directed to take this matter into consideration and pass appropriate orders thereon after hearing all the parties. So, it is further made clear that for in the interim or in the till appropriate orders are passed by the tribunal, status quo shall be maintained by all the parties to await the outcome thereof.
Much obliged.
Lordship, time frame may be given, Lordship, time frame.
No, we won't give time frame. Yes, it's expected, next is expected the matter will be disposed of as quickly as possible. Stop.
Much obliged.
Next paragraph, matter disposed of accordingly in terms of the directions contained.
Well, another point, my lord, because the respondent number 4 has relied upon the impugned order, my lord. Let the tribunal should not be influenced, my lord, by that. Because the respondent number 4 has relied upon the impugned order, my lord.
Is that an impugned order granting approval?
Yes, my lord.
That goes without saying. That goes without saying. You can, yeah.
Yes.
Because if he is good, take a look at the entire matter. Okay, yes.
In this, item 17.
Yes, Mr. Thapa has come. So,
in this matter, my lord, I was just going through this file, my lord. Here we have come with a very limited challenge, my lord. Challenge to the closure of our written statement by the tribunal, my lord. Here I was going through, my lord. I just saw one order, my lord. This is order dated 12/10/2022.
By this court?
By this court.
What does it say?
Here, my lord, the court has noted, my lord, in this proceeding, my lord, the recovery certificate has already been issued by the bank. Now, my lord, as of now, we do not know, my lord, what is the stage so far as the proceedings are concerned. My lord,
so you make it a ground for adjournment?
The recovery, beg your pardon, my lord.
You make it a ground for adjournment?
Not exactly, but my lord, it was my duty to bring it to your lordship's notice. My lord, if the recovery notice and pursuant to this recovery notice, if any action at all has been taken, my lord.
Yes, yeah, Mr. Das is
case,
Lordship, no actions has been taken, waiting for the outcome of this proceedings, Lordship.
In that case, my lord, that's what I was saying. But if that be the case, my lord, the entire, perhaps the hearing would be just an academic exercise, my lord. That's why I wanted to know what is the exact position of.
So we'll close it then.
Proceeding.
You challenge the recovery.
So, my lord, if that is the case, if the recovery proceeding is subject to the outcome of whatever this honourable court, to the orders passed by this honourable court,
we can't make it so convoluted because it is on a parallel footing altogether.
Because, my lord, just even if you recall, if your lordship allows recall of written statement, my lord, then the recovery proceeding would stay.
You see, the court will not be inclined because seeing the conduct of the parties, no written statement after repeated time was given, even then no written statement was filed.
No, my lord, here the only
so
issue
whether that kind of conduct can be condoned, that's the only thing.
The thing is, my lord, the closure of written statement automatically does not take the proceeding ex parte as against me. But in this case, that has happened.
We never appeared after that.
No, we did appear, my lord. We were not even allowed.
When you can still take part in the
after
proceedings.
The matter
even order of ex parte hearing is given also. In the end, you can even take part. There's a judgment of some Punjab High Court, I think, that that even if ex parte against you, you still can.
Yes. True, my lord. But here in this case, if I'm not wrong, my lord, we were not allowed any participation any further after the closure of written statement and passing of an ex parte order. I was only praying, my lord, can we have this tomorrow, my lord, subject to your lordship's convenience. In the meantime, I'll just seek instructions, my lord. Can I have this
they
tomorrow?
have said that the recovery certificate has not been acted upon.
If that is the case, my lord, let it be. Because here on the last occasion when my lord senior was not appearing, somebody else's was appearing. They were, my lord, in fact, they impressed upon this honourable court to vacate the stay. And if they sought to vacate the stay order passed by this honourable court, my lord, it wouldn't be for to wait for the outcome of this proceeding before your lordship.
See, there's no stay in the proceedings, correct?
There was, my lord, if I'm not wrong.
Of course, Lordship, on 26/10/2022, This order was passed to maintain the status quo till next date. The next date was fixed on 17/11/22. But thereafter it is not extended, Lordship. Status quo.
If I'm not wrong, my lord, one Mr. Nandi was appearing earlier, if I'm not wrong. He again disappeared after the getting an order for vacation of the stay order. Then subsequently, my lord,
we'll hear the after tomorrow.
Lordship,
this matter after tomorrow is a fixed matter in the supplementary list. You come prepared,
my lord.
20.
Please, Lordship. Project this matter may be taken up on some other date.
And of the board.
Lordship, the
very short matter, my lord. Very limited prayer, my lord. I'm not seeking for a regular appointment, my lord, as a matter of right. All I'm praying for is, my lord, that the advertisement should be issued, my lord, for special recruitment, which has been the practice in the department, my lord.
Whether we have to hear that.
Yes,
whether manifest can issue, can you direct them for issuance of advertisement?
Well, at least take steps. The government has to.
He is not ready. You're not ready.
Lordship, the arguing council is on legs before the.
Who's the arguing council?
The Mr. Khalid Khan, Lordship. Lordship, on those issues, I've already plainly brought before the affidavit.
Have you filed affidavit?
Lordship, as per my preliminary objections, I've already submitted to a point of law which are relevant in this case, Lordship.
In the affidavit, they say you don't have a right to be regularized. I'm not asking to be regularized.
And Lordship, mandamus cannot be given to
what?
To the government.
Look,
as per my limited law.
13 years, my lord.
As per my limited knowledge, Lordship, mandamus can be given to the.
What's the matter about you say that they're vacant posts in the department?
Lord, there are rules, my lord. There's a scheme, rules of 2002, wherein, my lord, advertisements have been issued calling for candidates to go for postgraduate diploma training. So, my lord, in terms of the rules, what we are required is during the training we are paid stipend, 2 years training, and thereafter we are required to serve the department, my lord. Compulsory, my lord, mandatory. So we are serving for the last 13 years, my lord. Now, as a matter
what kind of pay are you getting paid?
Regular payment.
Against the vacant post?
Against the vacant post, my lord. Now, as a matter of practice, what is being done over the years is these trainees who come back and join service, my lord, they issue advertisement by.
And they're accommodated.
Yes, my lord, for special recruitment, my lord. And in fact, a similar matter also.
So how many posts are vacant now?
My lord, kindly have page 53, my lord. I've prepared a chart, and this chart was prepared when I filed the writ petition. As on today, I'll just point out to your lordships how many posts are vacant. Page 53, my lord.
This chart made by you?
Yes, my lord.
Very complicated looking chart.
No, my lord, it's fairly simple. So at the top is the director, my lord. Then below the directors are the joint directors. Now we come to the left side of the chart. Left side of the chart, there is Deputy Director Sericulture, my lord. Below that is Zonal Officer Sericulture, Principal STI, Sericulture Research Officers. And below that, my lord, is District Sericulture Officer.
Okay.
Now, my lord, there are total of 8 posts at the level of District Sericulture.
You're serving as what now?
My lord, we are serving as instructor, my lord. So, my lord, at the level of District Sericulture Officer, there are total of 8 posts, all the 8 are vacant. So that is promotional post. I'm not concerned with that, my lord. Now, below that, my lord, there are altogether 20 posts, my lord.
Extension Officer 15.
Yes, my lord, 15, 1 and 4. All the 20 posts are vacant as on today. Why, my lord? There are no permanent employees below. Now, we come in the one below, my lord.
You're a what?
Farm Manager, Sericulture Inspector, Reeling Foreman. Altogether, there are 28 posts. Out of 28, my lord, only 15 are occupied, that too on ad hoc basis.
Okay.
And 3 are regular, my lord. So, my lord, they are, my lord, the big, my lord, the large amount of vacancy in the.
But they're paying a regular pay scale.
Regular pay scale. So, my lord, my limited prayer is
Suppose they advertise and you don't qualify.
My lord, my loss.
Okay.
I'll take the chance, my lord. My lord, a similar case had come up before this honorable court, my lord. In that particular case, they had sought for regularization, my lord, which this court had rejected. In that particular case, what the department had done is, they had intimated the MPSC to conduct the special recruitment.
Where's the order?
My lord, page 44. Similarly stated.
In this case, Lordship, the petitioners then were regularized according to the cabinet decision of 2007.
No, my lord.
Or 771.
Advertisement, my lord. This order speaks otherwise. If I may read, my lord, very short order. The petitioner have approached this court under Article 226 of the Constitution of India seeking regularization. So they had sought for regularization, my lord, of their service on the post of weaving inspector in the office of Directorate of Sericulture and Weaving Department as approved by the Cabinet White Memo number so-and-so dated 27/8/2007. Challenge is also being made to memo number so-and-so dated 9th of February 2018 issued by the respondent number 6 Director Sericulture forwarding the fresh draft advertisement to the respondent number 11 MPSC. Learned counsel for the respondent number 1 to 9 referred to Annexure 32 to submit that in pursuant to the personal department letter so-and-so, the MPSC issued a draft advertisement for regularization of the service along with the approved list for special recruitment. So this is what I'm asking for. To the two post of weaving inspector in the scale of so-and-so. In the office of Directorate of Sericulture and Weaving Department. Reference was also made to Annexure 33 by the Learned Counsel to submit that Under Secretary Government of Meghalaya Sericulture and Weaving Department had informed the Director Sericulture Weaving Meghalaya that both the petitioners, that is so-and-so and so-and-so, have already been approved for regularization by the Personal Department in the year 2007. Para 3 is important. In view of the above, no cause of action arises to the petitioners at this stage. However, a prayer was made that the direction may be issued to MPSC to conclude the process. So, regularization was not accepted. However, in terms of the practice...
So, your only prayer is that the vacant posts are there.
You advertise
the post.
Yes, my lord. As what has been done in the department.
What is in affidavit?
Affidavit, my lord, they say you don't have a right to be regularized. I am not asking for that, my lord. You don't have a right against the post. I am not claiming any post. All I am saying is you advertise. I'll just take your lordship through the affidavit. They bring in Uma, Devi, everything, my lord. My lord, page 2. Page 2, preliminary objections, my lord.
No, you're not seeing directions to be appointed. You just, yes, Mr. Karuna, we'll have it next week. It's just then Mr. Khan to be ready.
Gosh.
We'll see how difficulty is. This is a matter after 1 week on the prayer of the respondents on the ground of absence of the senior High Counsel.
Watch.
Second call, item number 5.
I oblige.
I've done the People Act, 72 People Act.
May I please?
Yes.
My lord, here the basic objection raised by the respondent is that my petition bar by section 80 of the RP Act, my lord. Now let's have a look at section 80, my lord. May I please, my lord? Section 80 says, my lord, that no election shall be called in question except by an election petition presented in accordance with the provisions of this this part. Now, my lord, I am taking lordship to my prayer, my lord, so far this writ petition is concerned. My prayer is, my lord, only that it is therefore respectfully prayed that lordship may be pleased to issue a rule calling upon the respondent 126 to show cause as to why they should not be directed to register a case against the respondent number 7 on the basis of complaint dated 23/2023 and FIR dated 3/4/23 lodged by the petitioner, investigate the same and take action as per provisions of RP Act. So my prayer is, my lord, regarding whether whether the respondent
validly
yes,
selected or not.
yes,
It's only the main complaint.
yes, my lord. Now, my lord, they have admitted that I made the I have lodged an FIR, my lord, and I'm just taking lordship to page 47 of my petition, my lord.
Yes.
Page 47 is, my lord, a letter written by the police in response to my FIR, my lord. May I read, my lord?
Yes.
And such, sir, inviting to the above noted subject, whereas an FIR was received from your end against the local sitting MLA of 43 Williamnagar constituency, Sri Marcus N. Marak, and his party, that is National People's Party, under the captions complaint in respect of misleading advertisement, objectionable advertisement, misguiding the voter by none other than Mr. Marcus N. Marak and his party, National People's Party, wide letter dated 23rd March 23. Upon receipt of the FIR, self has initiated preliminary inquiry into the matter and found the allegations made against the said person in his party, National People's Party, was violation of the Model Code of Conduct and purportedly publishing of misleading and objectionable advertisement and misguiding the electors by circulating a report card dated 2018-22 during the election campaign and during the period of Legislative Assembly election 23. It is clearly emphasized that under the Representation of People's Act 1951 and the Code of Election Rule 1961, that returning officer has the authority to receive complaint and act upon such matters for taking further necessary action. In view of above, I therefore request your kind self to take up the matter with the said competent authority for necessary action. So, my lord, the fact that I lodge a complaint, my complaint, my lord, established the violation of some provision of law, my lord, and the competent authority is my lord, returning officer. Now, my lord, so, my lord, according to the police, returning officer should have taken action, my lord. Now, my lord, I have lodged to the election commission also as well as the police, my lord. Now, the police has said that the election commission, election authority will take action, my lord. But election commission authority have not taken any action. Apart from these, my lord, the actions alleged by the offences alleged by me, my lord, they are also in violation of the provisions of IPC, my lord. My lord, section 153, just to lordship to section 153A, my lord. Section 153A says, my lord, promoting enmity between classes.
Okay, yes.
So, my lord, I have, my lord, it is a fact, my lord, admitted position that I have submitted to the police, my lord, pen drive, in which, my lord, this respondent 7 was, my lord, propagating something which was, my lord, hurting the sentiments of a religious class, my lord. So, it is also punishable under section 153A, my lord. Now, my lord, it is also an admitted position, my lord, that he has shown some report card which contains certain false statements, my lord. That is also, my lord, punishable under section, my lord, 163 IPC, my lord. Public servant framing an incorrect document with intent to cause injury, which is also punishable with 3 years, my lord. Apart from it, my lord, section 171F, undue influence at an election, it is also punishable under IPC, my lord. Section 170G, false statement in connection with election, it is also punishable under IPC, my lord. So, my lord, my complaint and my FIR, my lord, apart from being punishable under section 125 of, my lord, RP Act, electoral offence, my lord, they are equally punishable under IPC also, my lord. I am not challenging his election, my lord, by this petition. I am just seeking, my lord, the direction that the authority may be directed to register a case and investigate, my lord.
Okay.
And now, my lord, I am just taking lordship to a judgment of our Honorable Supreme Court, my lord. It is reported in 2021, volume 12, page 780, my lord. May I just take lordship to para 21 of that judgment, my lord. Para 21, my lord. May I read, my lord?
Yes.
para 20, we need to first notice that nature and extent of jurisdiction of the High Court under Article 26 of the Constitution of India, the power of judicial review vested in the High Court under Article 226 and this court under Article 32 of the Constitution is an integral and essential feature of the Constitution and is basic structure of our Constitution. The jurisdiction under Article 226 is original, extraordinary and discretionary. The lookout of the High Court is to see whether injustice has resulted on account of any decision of a constitutional authority, a statutory authority, a tribunal or an authority within the meaning of Article 12 of the Constitution. The judicial review is designed to prevent cases of abuse of power or neglect of a duty by the public authority. The jurisdiction under Article 226 is used for enforcement of various rights of public or to compel public statutory authority to discharge the public functions entrusted on them. The courts are the guardians of the rights and liberty of the citizen, and they shall fail in their responsibility if they abdicate their solemn duty towards the citizen. The scope of Article 226 is very wide and can be used to remedy injustice wherever it is found. The High Court and the Supreme Court are the constitutional courts which have been conferred right of judicial review to prevent the fundamental and the other rights of the citizens. So, my lord, my case, my lord, I am just complaining, my lord, my right. I am just asserting my right as a citizen, my lord. If the respondent 7 has violated any provisions of our RP Act or IPC, my lord, his actions are to be investigated, my lord.
Yes.
Now, my lord, further para 22 of this same judgment, my lord. And my lord, election commission, my lord, election commission is also, my lord, one of the authority, my lord. So there is no, my lord, the bar created by section 80 of RP Act does not, so for my case is concerned, it has no applicability, my lord. Because I am not challenging his election, my lord. I am just challenging his, my lord, some of his actions. If these actions are, my lord, punishable, he must be face that trial, my lord.
Yes.
Para 22, my lord, just the nature of jurisdiction exercised by the High Courts under Article 226 came for consideration by this court in large number of cases in Sangram Singh versus Election Tribunal. Article 226 of the Constitution of India is in reference to Section 105 of RP Act came for consideration. Section 105 of RP Act provided that every order of the tribunal made under this Act shall be final and conclusive. Argument was raised in the above case that neither the High Court nor the Supreme Court can itself transgress the law in trying to set right what it considers as an error of law on the part of the court or the tribunal whose records are under consideration. It was held that jurisdiction of High Court remains to its fullest extent despite Section 105. This court also held that the jurisdiction of High Court in Article 226 and under Article 136 conferred on this court cannot be taken away by a legislative device. In para 13 of the the following has been laid down. Para 13, the jurisdiction under Article 226 and 136 conferred entitles the High Court and this court to examine the decision of all tribunals to see whether they have acted illegally. That jurisdiction cannot be taken away by a legislative device that purports to confer power on a tribunal to set illegally by enacting a statute. That its illegal acts shall become legal the moment the tribunal chooses to say that they are legal. The legality of an act or conclusion is something that exists outside and apart from the decision of an inferior tribunal. It is a part of law of land that which cannot be finally determined or altered by any tribunal of limited jurisdiction. The High Courts and the Supreme Court alone can determine what the law of the land versus all other courts and tribunals, and they alone can pronounce with authority and finality on what is legal and what is not. All that an inferior tribunal can do is to reach an tentative conclusion which is subject to review under Article 226 and 136. Therefore, the jurisdiction of High Court under Article 226 with that of the Supreme Court above them remains to its fullest extent despite Section 105. So far my case is concerned, my lord, they are my lord, banking on my election petition, my lord, which I earlier filed, my lord, that my election petition was barred by limited. So that's why, my lord, we withdraw it. So, my lord, withdrawal of my election petition or failure to, my lord, take the process through election petition does not bar the petitioner to my lord, to set the process of law at motion if that other remedy is available, my lord.
Right. Yes, Mr. Abhijan, that's it.
May I please also?
Yes.
What has been argued orally, my lord, that IPC offences, etc., my lord. Kindly see the writ petition, not a single line, single averment in the writ petition. And it is nothing but replica of what was there in the election petition, my lord. Kindly see page 4, page 5, paragraph 4. Is the page 5, paragraph 4 is the details of election and the election of respondent number 7, my lord. Now, allegation, if your lordship will notice it at page 7, paragraph 6. First, the allegation is that had applied various corrupt practices such as misleading, objectionable advertisements, and with a view to misguide by misrepresenting the voters with false statement by circulating fabricated and baseless report card of 2018. So allegation against respondent number 7 is, my lord, that he has circulated the report card which is baseless as per the, according to the petitioner, it is a baseless thing, and therefore action should be taken against him, because why did he circulate the baseless thing, my lord? Now your lordship will see the contents of that is repeated in page 8, paragraph 7. Under education sector, road, etc. What he says that whatever is being claimed by the petitioner, my lord, according to the petitioner, whatever is being claimed by respondent number 7 in his report card is not correct, is not factually correct, what he says, my lord. This is the basis of, and paragraph 9 where he alleges, my lord, at page 11, that respondent number 7 has illegally used and violated during the model code of conduct. So violation is that he has there is a violation of model code of conduct. Then he refers to various there is nothing like FIR, etc. Now, my lord, kindly see what is the FIR which he is referring to. If your lordship will see the prayer is what he claims that it is a FIR. Your lordship will see the prayer at page 18. Register 1 to 6 to show cause as to why they should not be directed to register a case against respondent number 7 on the basis of complaint dated 23rd February 2023, my lord. Now kindly see 23rd February and also your lordship FIR dated 3rd April 23. Now your lordship will see the complaint dated 23rd February which is at page 36, my lord. Now, this is a complaint by a candidate, my lord, UDP candidate. So what I say is that he is a politically motivated person. And if your lordship will see the content, so-called, he has placed the FIR.
This page
36.
By whom?
This is by some UDP candidate south.
Not by him.
Not by him. And what he is coming, and he is not disclosing also, my lord. To your lordship, he should be fair. At least he should have told that, he should have informed this honorable court, my lord, that 23 to...
That is FIR.
Yeah, and what is the FIR, my lord? The content of that also your lordship will see. In uploaded video which has already gone viral, General Secretary of NPP by William Nagar, so-and-so, along with 5 others have seen singing their version in devotional song was replaced by word NPP. So this is the complaint by a candidate who is contesting election, and he is set up
in all likelihood the petitioner is set up by this candidate below. He has failed in election petition, and that is why he is making this kind. Now the second thing which he says, FIR, my lord, again page your lordship will notice that 42-46.
42-46?
Yes, the direction which he has sought, that this is the FIR.
Page 42.
42, my lord. Again he says that the advertisement issued by the respondent number 7 is objectionable, is misleading, and therefore action should be taken under the model code of conduct, my lord. He comes before your lordship by way of election petition, which is at page 48. Your lordship's order is at page 48.
The second is 3rd April.
Yes. 42 is your lordship will find. In 42, at page 42, my lord, he says that whatever advertisement issued by the respondent number 7 is violation of model code of conduct. So, and he goes to the police also. I don't know how, under which provision of law police has.
Where is the model code of conduct violation?
Your lordship will see the complaint in respect of reference misleading advertisement, objectionable advertisement, misguiding by voters, none other than Marquis part. Yes, and then your lordship will see at the bottom. Moreover, the violation of model code of conduct imposed by Election Commission of India by notification dated so and so.
Yes.
So this his allegation is that the candidate respondent number 7 has violated the model code of conduct during the election, my lord. Now for that purpose he files the election petition, my lord.
Yes.
And then your lordship at page 48, wide order of your lordship dated 25th May 2023. He knows that he has no case and he has lost the election badly through he is representing somebody, UDP or I don't know, because he says that liberty to seek efficacious remedy in accordance with law. Your lordship is granting liberty only in accordance with law. The first and foremost objection which we have raised, my lord, that there is a bar under Article 329B, my lord, 329B of Article, and we have said so in counter affidavit clearly. He has not answered that. He has not met that argument. In the first preliminary objection is as to the maintainability of the writ petition, my lord.
Yes.
Is with regard to bar created under Article 329B, my lord, which no election to either House of Parliament or to the House of, it clearly says, my lord, notwithstanding anything in this constitution. So this very provision, no, and B, my lord, says no election to either House of Parliament or to the House or either House of Legislature of the state shall be called in question except by an election petition presented to such authority and such manner as may be provided by or under any law made by Parliament. Now, under 329B, my lord, the RP Act, Representation of People's Act, has been drafted, my lord, and the remedy is provided in Section 80, my lord. He tried, he exhausted his remedy, he did not succeed there. Therefore, maliciously he files this writ petition, my lord, which clearly creates a bar, because this 329 bar of writ petition, my lord, was subject matter of Constitution bench judgment way back in 1952, my lord, which is annexed with my counter affidavit, my lord. And if your lordship will see, the judgment is annexed, very short judgment of 1952, and that principle is being followed till today, my lord, uninterruptedly and without any. And your lordship will see paragraph which we have quoted the relevant paragraph also in the counter affidavit, which my friend has conveniently omitted. Kindly see paragraph 20 of the judgment, my lord, which is annexed with the writ petition. Paragraph 20 of the Constitution bench judgment, my lord, at page 21, my lord, of the counter affidavit. This is MP Punnuswamy, my lord. It was argued that since the Representation of People Act was enacted subject to provision of the Constitution, it cannot bar the jurisdiction of the High Court to issue writ under Article 226 of the Constitution. This argument, however, is completely shut out by reading of the Act along with Article 329B. It will be noticed that language used in Article and in Section 80 of the Act is almost identical, with this difference only that Article is preceded by words. Notwithstanding anything in this Constitution, I think that those words are quite apt to exclude the jurisdiction of the High Court to deal with any matter which may arise while elections are in process. It may be stated that Section 107 of RP Act in England drafted almost same language, my lord. So after dealing with, so the bar is under 329B in my humble submission is absolute, my lord. And the fact of the matter is that all these allegations are nothing but allegations pertaining to election of the respondent number 7, my lord. And on that basis, he is terming those allegations as FIR. In cognizable in CRPC, my lord, only cognizable offence can be termed as FIR. All complaints of violation of Model Code of Conduct cannot be termed as FIR. And Sakri Basu and all those judgments are there. If he has some case, he can go to the magistrate under 153, but he has no case, my lord, because he is set up by the candidates who have lost the election and they want to challenge the election by hook or crook. That is what, and this is a malicious petition filed, my lord, and I would pray that your lordship may impose heavy cost.
We'll pass orders.
My lord, just for Mother SG has said that we have not made any statement. My lord, para 11 of my petition, my lord, I have made that this complaint was made by my lord, one member of a Baptist Church of Tura, my lord. And I made it clear that it is not made by me.
And but he is coming for registration of FIR on his behalf.
No, just a minute. My lord, and surprisingly, my lord, what the learned advocate general has to say, my lord, I am simply seeking a direction to the police, my lord. Now, whether the police has investigated my complaint or not, my lord, I think the election commission or my lord, this home ministry, they have nothing to do, my lord.
You're not questioning election, you said.
No, I am not questioning the election.
Not challenging the election, only that against the action to respond.
And my lord, so far the FIR is concerned, it is not necessary that I have to mention the provisions of law in my FIR. My FIR should, my lord, only disclose the facts, my lord. Now, my lord, what provisions of law has been violated or offence has been committed, it is the police to decide, my lord.
At least facts should disclose some cognizable or non-cognizable offence.
My lord, if my complaint does not disclose any offence, my lord, the police will file an FIR, my lord.
Yes, Mr. Dr.
Election Commission. I filed an affidavit with 2 short points, my lord. My lord, your lordship will kindly see the complaint that was submitted by the petitioner, my lord, to us, my lord. That is at page 38.
In your affidavit?
In the writ petition, my lord.
Yes. 23rd March.
My 23rd March, my lord. My lord, in para 3 of my affidavit, my lord, affidavit of respondent number 1 and 2.
Yes.
We have said, my lord, if I may just read, my lord, few lines.
Yeah, affidavit. Yes.
Para 3 of the affidavit, my lord.
Yes.
That the deponent further state that petitioner along with his complaint dated 23rd March 23 had attached a pen drive with video clips in local language and the other details such as source, date and place etc. regarding the video clips were not clear. It may be mentioned here that the elections were notified on 18/1/23. The date of polling was 27/2/2023 and the results of the elections were declared on 2nd March 23 and the complaint was submitted on 23rd March 23 after the election process was over. As such, since the elections was already over and the Model Code of Conduct ceased to be enforced by the time the complaint was submitted, the Commission did not take any action on the said complaint. After the elections were over, the only remedy available to the petitioner, subject to establishing his locus standi, was to file and pursue an election petition, which the petitioner failed to do within prescribed time limit of 45 days from the date of declaration of election results, and therefore his EP number so-and-so was closed on withdrawal and was disposed of by the order date so-and-so. The instant writ petition as such is not maintainable and hence liable to be rejected in limine.
You pass orders.
My lord, as far as the police allegation, my lord, he has alternative remedy under 154 subsection 3 of GRPC. If at all there is anything.
There is no bar. This honorable can issue a direction. No, there is no question of fishing inquiry. I am just seeking the police may be directed to investigate the case and register.
It's like old wine in new bottle.
Not only that, it's just the labels been taken up and stuck again. Yes. Yes. Shulai, what submission you have to make?
I'm sorry, Your Lordship.
Yes.
Lordship, in this board cases, item number 14 and 15, these are same, Your Lordship, under the same impugn notification, Your Lordship.
Yes.
Lordship, if Lordship kindly come to page 25, annexure 8 of the writ petition.
Yes.
Lordship, the order of termination has been issued in view of the order dated 2/11/2017 passed by in writ appeal number 31 of 2017, Your Lordship. What happened, Your Lordship? In this case, Your Lordship, these people, all this name, Your Lordship, appear in the impugn order. They are all from Dadingkri subdivision, Your Lordship. Their name, Your Lordship, appear to be they were tainted candidates appearing in the report of the CBI as well as the high-level scrutiny committee constituted by the order of the division bench, Your Lordship. So, in view of that, Your Lordship, that's why they were terminated. Lordship,
the case that they're not even appointed. They were never, the results were never there. Results were there. Successful.
We are not appointed in pursuant to the advertisement, pursuant to the result declared. Our case is simply contractuals. Lordship, it will not be applicable to the contractual candidate. It is extended 59 days.
No.
They took part in the selection process.
Mr. Shulai, just listen.
Just a minute.
Just listen.
Lordship,
they are trying to make a case that look, we're not bothered about selection process. We're not bothered. We are contractual teachers, and the order only applies to people who are regularly appointed, who are tainted or not tainted. That is the only case. So if we might be tainted, but then we might be tainted. Why should it affect the contractual service?
They took part in the selection process. They took part in the selection process. Your Lordship, the report of the CBI revealed, the report of the high-level security committee also revealed that they took part in the selection and they were found to be tainted. Your Lordship.
So because of that, they are to be removed from contractual service also.
Lordship, if Lordship kindly.
That is definitely not applicable to our case.
You get the benefit also, although you have participated.
If Lordship kindly
appointed
against the regularly selected candidates.
Lordship, if Lordship, I'm taking out only the conclusion and direction passed by the division bench. If Your Lordship kindly come to D, Your Lordship, internal page 102, Your Lordship.
102?
Lordship, yes, internal page, Your Lordship, on top, Your Lordship. It is on top.
Yes.
Lordship, kindly see D. None of the candidate who has been found tainted, blemished, whether in the report or board, also none what by the poll shall be taken or retained in service, even in stopgap arrangement, and the service of every candidate who is yet to be continued, whether by way of regular or shall stand tainted with immediate effect. This is the judgment of the division benches. We are bound by this judgment, Your Lordship. We are bound by this judgment.
The order passed on 2017, and I filed a writ petition before the court 2019. And when the direction was given by the court, then according to I was allowed to continue till today.
Lordship,
so the order of 2017 was not implemented. Now all of a sudden they have terminated my service by saying that you are not.
With due respect, Your Lordship, so that order allowing to the petitioner to continue, Your Lordship, was passed only on the motion state, Lordship, without giving an opposition to the state to present its case.
Yes.
But if they file an affidavit, then we can reply to that. But
in the meantime, we shall continue.
Because there was some more order passed by the High Court. Because we are not pressing on that. There was a review application. There was a case. We went to Supreme Court.
No. This what just because of the virtue of motion at the motion stage. After 2020, what happened in
Lordship,
this case?
can you see?
What happened with 531 2019? What was the culmination of that case? The 531, the next year, 4 page 20. What happened to this case? How did it end?
21.
Of this petition, page 21. What happened to this case?
This case disposed of.
This is all
How?
disposed, Your Lordship.
Lordship, this case was disposed of
Where's the order?
by 24th.
What's the order? What does the order say?
The 24th is that MF Constitutional and Counsel for the Petitioner state that.
Where? Which page?
Page 24.
Okay, very good.
Then, Lordship, can you see?
One second, Mister. Don't be in such a hurry, Mr. Shula. You're catching a bus or plane or something. Oh, so finish.
Instructions. Why? Because they are reinstated. It is because they are reinstated. Because of they have reinstated. Now, 2017 order.
So that's gone. That 19 order is gone also.
2017.
Justice Rafiq is gone also.
Lordship,
died a natural death.
The government filed an affidavit in this case, but the government never said that you are not eligible because of this reason.
No, not that. We cannot take the affidavit of the other case.
But not see, only if they file an affidavit we can reply, because after that the division bench order also, there was a order passed by the justice review application was filed. The candidate went to Supreme Court. So much thing happened thereafter also.
No, nothing happened. I know also these cases because few also came for the bench, and they also, in fact, Justice Mr. Saman Khurshid argued the matter before this bench also.
So my case here only is because I was continuing till 223.
We understand.
And now all of a sudden, without giving.
And if you want another thing, forget about any selection. Contractually can be terminated any time.
No, they can terminate.
So that is the only thing that's
they can terminate with.
So the only thing is that now you can stand. You're terminated now. The only thing is that are you stigmatized? But you're found tainted. So what's the question of stigma also? So you have no case. Even forget this division bench order also. Contractual appointment over. You have to go and file a suit.
No contractual, but
what is contractual appointment?
Contractual,
you say it's gone by contract. So well 2 to 6.
No, a simpliciter is the okay. So if
no,
you say it's a simpliciter, then I can be ousted from the service.
It just says that ousted from service, you're contractually over.
Yes. No, that can be. If that is the order, I have no right. But here the order is with something, you are tainted.
Tainted because they may be wrongly, but then the factum of the nature of your engagements contractual, right?
Yeah, only that.
And then, so what does the terms of contract say?
59 days.
So you can't seek to enforce your contract by writ petition.
Only if they can.
And so I will not look at this. Yes. Will not look at the tainted, non-tainted. Now tainted because you have been found tainted. So they may have a stigma is not there.
That is a stigma, Lordship. If the stigma is removed, because I'll be debarred from all the future employment. I will not get the.
You are tainted, right, in selection process.
They say that is there.
So no, that is final. Who's tainted, untainted? That's been final. CBI is gone. High-powered committee is gone. Then again, examination of repetitions by Chief Secretary and Constituent Committee is gone. That's all water under the bridge. Now I will say that since your contractual is over, it's over. Finish.
No, but the contractual with the stigma, they have passed the order.
Stigma tainted.
You are terminating you because you are tainted.
No, you are tainted. Yes.
So if I say terminated because some other candidate, regular candidate has come, now your service is no more required. But here the case is that because of you tainted. The word tainted is very dangerous for me because I will not get the future employment also.
But why dangerous? You have to disclose that you are tainted, right?
No, but because if they give a opportunity of showing cause, at least we can explain to the government, this is my positions, and I'll explain everything. The government can pass a decision, pass an order. It is independent or decision may be taken by the government.
Again, reiterating that point, even if the decision bench order also not taken consideration also. Contractual, you have enforcement. What rights have been violated? Tell me. You come to the 2 to 6 for equity.
Equity only because
you follow the law. And what law has been violated? What rights have been violated? Tell me. What is the right been violated?
My right only is violated is principle of natural justice. They have not given me opportunity of showing cause that I am tainted. Why I am tainted or not tainted?
But then tainted in the results.
Only notice if the government could have taken some independent decisions that in view of the judgment and all other aspects.
Now you understand one thing, that pursuing this will lead nowhere also. If I short affidavit then.
Lordship, can you see, come to paragraph 2, Your Lordship, of the same judgment, Your Lordship, at page 103, Your Lordship. that chance, Your Lordship, of giving.
No, forget that. We're not going to go tainted, untainted. Forget about that. That was not concerned a little bit also, because they became ample opportunity to represent against very tainted or not. There was a reappraisal, reappraisal again. We're not going there. We're going to touch that. That is like, what is a hornet's nest? That wasp, is there. If you poke it all the around, nothing will come out. So what are you seeking? The only thing he's seeking is that what you're trying to get from this writ petition, as any good lawyer will do, is for continuance of your service.
Regular selection.
Forget it. Good one.
That is our main prayer, Lordship. We have served almost 12 years, Lordship. More than 12 years. That is
59 days over. Last extension was when?
Last extension.
When was that?
It was every 59 days they have to give.
Where's the last extension? Let's see a petition. Last extension was when?
Your Lordship will find at page 24 or page 23, Your Lordship.
Last extension.
This is 19. This is not in.
This is Your Lordship 20th Jan 2020. Then thereafter, Your Lordship, there is no thing on record to show that.
No, it is extended from time to time.
But there is no documentary evidence. Your
No, from this Annexure 25 itself, it shows that I am in service. There is a reason I am terminated.
You are paying for Shahanur Islam.
no, Lordship. I am for
Coach,
Manoranjan Coach, Lordship. I did number 4.
Manoranjan Coach in item number
Lordship.
15, Your Lordship.
My case is slightly different. I came to the court, Lordship, when that extension was, when that contractual was not extended. Then I approached this honorable court, and this honorable court was direct me to file a case representation before the concerned authority. Then accordingly I filed representation and
So you filed representation now against this.
Director
Yes,
has
yes. Some order may be passed, Lordship, so that we can file it. We can approach them.
my lord, my order passed by the director is really clear, Lordship. That till the regular selection is made, I may be allowed to continue.
In my case also same.
That is that case, Lordship.
In my case also
22, Lordship.
Yes.
Similar.
Last para, Lordship.
Last para. Where? Page?
Page 22, Lordship. I am not praying for regularization, Lordship. I know my limitation, Lordship.
To continue on.
At least, Lordship,
Till the regular.
till
The regular candidate.
appointed.
Lordship, in fact, in some other writ petition, that is in WPC number 555 of 2019, Lordship was pleased to pass the order that filing of allowing them to file representation, Your Lordship. Then also in another writ petition also 109/2022 also same relief, Your Lordship, allowing them to. Lordship, this is from my instruction, Your Lordship.
So what happened? You extended also?
No, Your Lordship.
They consider
it should be instructions to your officials, like representation which merits, not just because representation is filed.
They have been all have been rejected, Your Lordship. Their representation have been rejected, Your Lordship.
See, but the thing is, this fellow has been appointed 2010. What's your qualifications?
I fulfill the NCD norms, Lordship. The present.
Oh, see. Oh, because this order extension was passed because on the shoulders of Mr. Kurshi's client.
Yes.
So everyone's piggybacking on each other. The whole thing comes full circle then.
All four.
Yes, Ainul Haq will piggyback on Manoranjan Coach. Manoranjan piggyback right on.
And all this, Your Lordship, all their representatives were rejected, Your Lordship, on 31st May 2023, Your Lordship.
But the fact is, we are in service.
Where's the impugn order in your case? Last one.
24, Lordship.
Page 24.
Same.
Page?
Page 24, Lordship.
Same.
Yes.
Same.
So what do you propose to do? What mandamus you seek?
My God.
That the show cause be given to you?
Yes.
In fact, show cause was not given. Immediately, show cause was not given, and I was not part.
How was show cause if we given a contractual?
Then there was no need.
If it goes back, what they'll do is only they'll say that contractual period is over, we're not extending. Over. Finished.
But they put the tag tainted, Lordship.
Tag, remove the tag tainted. Pass fresh orders of termination.
Let them come with a fresh representation. We'll.
In fact, they should issue a notice of showing cause. Then why your service should not be terminated? Then we'll in reply to that.
There's no question. There's no question. Mr. Kurushi, you're a seasoned veteran in service matters. You know very well. There's no question of issuance of show cause for a 59-day appointment. Once you issue show cause, that means it has the trappings of regular appointment. See, once a show cause given to you, you say, oh, show cause given to me, that means I'm considered a regular employee. So you'll come to the High Court like, why did you issue me show cause? You know, show cause shows that treating me as a regular employee and I've been paid regular scale. So for all practical purposes, without breaks, you say that no, these breaks, all artificial breaks, show cause has been issued, so I'm a regular employee. So we can't have that.
We will not take that ground.
Of course, that ground has to be taken. If you're a lawyer, you take that ground. What is there?
No, pursuant to the order of the
whatever
court,
you do is to help your client. So why? That is for the court to decide. You throw it the court. You throw it the court. You say yes, I've been show cause. I've been show cause. Being show cause means what?
No,
being show cause means that you know that DP is contemplated against me.
Yes.
So DP is what? I'll come under the discipline and appeal rules. I'm considered a regular employee.
Opportunity of hearing or whatever the title, so that I can remove the word tag tainted. I can explain that I'm not tainted for the purpose of.
We'll dispose it off.
In my petition, some pending challenges were there because on the strength of the order passed by the director lordship, I have been continuing the service.
No, so that whatever entitlements you will get.
Yes, we'll dispose of it.
Yes, take down. First, you take down item number 14, WPC number 253, 2023. Yes. The petitioner, who is stated to be an assistant teacher of a lower primary school, appointed on contractual basis you'll find it here in para 2 in Singimari Government LP School. Is before this court being agreed with. The order dated 1st July 2023, whereby the contractual employment has been discontinued. Has been discontinued by the respondent number, the in charge subdivision SDSEO. Yes. That's number 4. Yes. The reasons recorded in the order of termination is that the same was issued in conformity with the directives issued by this court in order dated 2/11/2017. Where is it tainted? Where is it tainted?
Second line, Lordship.
Second line, third line from the bottom, Your Lordship. The services of the tainted teachers. The services of the tainted teachers.
Directions issued in order with regard to the services of tainted teachers. Stop. Next paragraph. Mr. M. F. Qureshi, learned counsel appearing petitioner, agrees that the petitioner has no right to service as his right to service as his engagement is purely contractual on 59 days basis, which is extended from time to time. Stop. However, his grievance is that the termination order has recorded that the petitioner is tainted, which will dim his opportunities of future employment. In this regard, he prays that we be allowed to prefer representation before the respondent number 4.
No, Your Lordship, it will be before the director, Your Lordship.
Before the director, for the respondent.
Respondent number 2, Your Lordship.
Number 2. For consideration and for passing of necessary orders. Stop. Mr. Anishulai, learned AAG with so and so, has strongly resisted the submissions of the counsel for the writ petitioner by submitting that the order dated 2/11/2017 passed in present with appeal number 52 of 2011 passed in WA 52/2011 and other connected matters, has categorically held that tainted teachers should not be allowed to continue in service. Where have you read?
Lordship, paragraph D at page 102, Your Lordship. Second line from the bottom, Your Lordship. Even in the stopgap arrangement.
Mr. Anishulai and the AG has strongly resisted the submission of the legal counsel for the petitioner by submitting that the order dated 2/11/2017 passed in WA number 52 of 2011
and other connected matters
has categorically held that the tainted teachers should not be allowed to continue in service.
Even in stopgap arrangement, and that the service of every such candidate was yet continuing, whether by way of regular appointment or an ad hoc arrangement, shall stand terminated. Stop. He submits that in view of these express directions, the respondents are bound by the said order, and the service of the petitioners was discontinued by the impugned order. Stop. Next, heard the counsel for the parties done. It is undisputed that contractual service, especially in the nature of the petitioner's engagement, that is for 59 days at a time, no right has accrued to them to seek automatic renewal or to retain a contractual service, and whatever rights that derive from the engagement will be in the realm of private law. Stop. However, looking into the order dated 1st July 2023, impugned order dated 2023, it is noted as submitted by the petitioner's counsel that it is noted that the reason given therein is due to the teachers being tainted. in the selection process for upon assistant teachers. However, it is also further noticed that the writ petitioners how to put it, though had taken part in the selection process and their results and they having found tainted by a process that involved many years by multiple authorities. Absolutely.
However, it is also further noticed that the petitioners though have taken part in the selection process and they have been having been tainted by
Having been found tainted.
Having found tainted by the process involved
Multiple authorities. At this stage cannot agitate to have the said, to have the taint removed, and at this stage can agitate against the same. Stop. However, what representation, what purpose will it serve also?
Purpose will serve, will you just explain to them?
It will be a futile exercise.
Even after 2017 judgment, they allowed us me to continue.
However, as they allowed to continue in service, even after the judgment dated 2/11/2017, this court deems it fit that they be allowed to file representation, at least as to the terms of their discontinuance of service. So, accordingly, this representation is disposed of by allowing the writ petitioner to file a representation before the respondent number 2 with regard to the terms that are contained in the said impugned order. So, the said representation be filed within a period of 2 weeks from this order, and the matter be disposed of thereafter by the competent authority within a period of 4 weeks. Yes, your order?
Same order, Lordship.
Only that I have some pending dues, Lordship, because as per the order of the director, I have been continuing.
Yes. Okay, in his case, another thing, it has also been submitted then that some pending dues, that there's some pending dues, that there are pending pending dues, that some pending salary with regard to petitioner is still due. Stop. If that is the case, the same should be.
But only will examine that, Your Lordship. Suppose if they are not working, Your Lordship. They will not be entitled to,
this aspect also shall be examined by the that is one number 2 for disposing of the representation. Yes.
Apply, Your Lordship.
Hello.